Good evening, everyone. It's an honor for Delhi High Court Legal Services Committee to extend its heartfelt gratitude to respected dignitaries and all the empaneled advocates of the Dhclsc present here today. We welcome you all to today's capacity building program, which will be led by Mr. Shri Singh, advocate, on the topic The Art of Drafting, a Legal Way of Storytelling. I would request Mr. Arul Verma, Additional District and Session Judge and Secretary Dhclsc, to kindly present a potted plant and a memento to serve as a welcome gesture. Thank you, sir. Effective drafting is like a silent partner in courtroom victories, for it builds the foundation of a case on which oral arguments are laid. And to explain us how this silent partner can create noise in the mind of the opposition and bring stability to a case, today we have amongst us Mr. Shri Singh, a practicing criminal lawyer who represents and advises clients over the globe in disputes inter alia involving issues of anti-corruption, money laundering, extradition, and many more. Sir has worked on a number of leading criminal trials, including the Delhi liquor matters, the Religare Fortis trials, the 2G telecom trial, the Delhi Commonwealth Games, to name a few. I would request Mr. Arul Verma to kindly take the mic and address Sir.
Good evening, everyone. So, again, we are meeting after about a fortnight, I think. There are a lot of young, new faces also here. Okay, so now this, as you know, we are on a quest to enhance your capabilities. So, this is one of those sessions where we invited Mr. Shri Singh, and about Mr. Shri Singh, Shelly has already apprised you of all his achievements. Now see, it is tried that prolixity is to be shunned and brevity is to be embraced, and I feel one of the reasons for this adage is that too lengthy submissions would cause disinterest in the reader after a point of time. Our attention spans are short, and now with the advent of technology, those spans have become shorter. You have instant SMSs, you have shorts, you have those media bites. So we are gradually attuned to focus more on highlights or keywords. So in such a scenario, we would be wiser off in choosing our words carefully and be sparing in our employment of them while drafting our petitions and applications. So this is one aspect. Now another aspect that I want to tell you is the practicality and utility of employment of legal jargons. Do we use it? Do we avoid it? Now that is a decision I leave it up to you. But it is incumbent upon us that when we use sentences, we should try and simplify our sentences. We should try and not use lengthy sentences while drafting. And these are all aspects which you are aware of. But another aspect, or the last aspect that I wish to draw your attention is that writing skills should be like an art form, like a painting, like a sculpture, which will not only stimulate you but also achieve that vital goal of persuading the reader. Now this art of persuasion must be reflected in your writings and in your drafting. And as it has been said, present your facts like a bouquet of flowers, which is attractive and naturally invokes the interest of your audience. And your audience is, of course, the judge. And therefore it cannot be gainsaid that a legal writer who communicates factual information in a narrative form has an edge. Now you already have these skills. To enhance your already developed skills, we have requested Mr. Shri Singh to share his experiences, and I'm sure after meeting with him, knowing more about him, he inputs would be definitely very invaluable to all of us next time when you pick up the pen or tap away at your keyboards. So with these words, ladies and gentlemen, let's put our hands together for Mr. Sri Singh. Over to you, sir.
Good afternoon. Thank you for that very nice welcome. And I think for the last 20 years that I've been practicing, I haven't seen our friends in legal services being treated in this manner. And treated is the right word that I'd use. I think this was a very useful exercise first on my part to go over what I can distill in an hour on things that I've learned about drafting, and I hope some of this is useful to you as well. So let's start. I think the topic that was selected and had been curated for us is the art of drafting, the legal way of storytelling. I think Mr. Verma has already pointed out, he's used the word narrative, which I think flows from this. The draft is for us in our Indian legal system is almost always the first way in which our client communicates with the legal system. In criminal matters, we are taught from the very inception that you must be careful with the words that you use, how much information you actually transmit. You have a right to silence, so there is a constitutional imperative that vests in your client, that operates in your head, that he has or she has a right to silence, which you must respect, you must protect. But at the same time, you have to find a legal way to storytell. You have to tell a story. So that merging of those two imperatives, the first imperative, which is to tell a story, and perhaps in that story lies your client's salvation, that you are able to explain away why your client has acted in a way that he or she has or has not. But at the same time, you have the legal ability, you have the legal foreknowledge, so to speak, to know that this may not be the best time for you to disclose everything that your client knows about that particular case. So that balance has to be met not by your client, not by the court, not by the prosecutor. That balance has to be met by you. And I think it's finding that balance really that is something that we have to work to achieve. So these are some slides that I just use to try and guide what we are saying. So legal writing is distinct and from general or specialized forms of writing. And in this particular sentence is hidden really what is our purpose. Simply because one has or doesn't have a particular skill in writing English, in writing prose, in telling a story, does not immediately translate to being either good or bad at legal drafting. Legal drafting is a skill. It's a skill that is entirely different from any other form of writing, whether it is journalistic writing, whether it is writing from the scientific writing that you would have learned in school or in college. It is a skill set. It is a skill set that has to be practiced and that has to be earned over a period of time. And its purpose is distinct from any other form of specialized writing. We are fortunate to be in a legal system where in any variety of cases, criminal cases, writing is almost always accompanied by the ability to speak for your client in a courtroom. There are many legal systems, content legal systems, etc., which do not afford that right. So there, the significance of a draft is far more than it is for us, but be that as it may, you have to also remember that when you draft something, when you file it, at times in a judge's chamber or before a judge, if you are not present or if a judge chooses to read your file or if a prosecutor chooses to read what you've drafted, your draft is the only way in which your client is represented in that room, in that table, in that particular conversation. So you're not there to supplement the draft. As far as we are concerned as criminal lawyers, mostly operating on the side of the defense, it provides you the framework to conduct an effective oral argument. So if I have a good bail application before a judge, and if the judge has read that particular application, my ability to deliver oral arguments in what may not be a strictly limited period, but which is largely limited. But what is largely limited, that framework is provided by a good draft. And in some cases, especially in cases where, so say you are arguing a revision or you are arguing before a superior court, if your draft does not provide or does not plead the requisite details, you may be curtailed from raising those arguments in the future. So it is a document that may be prepared in the beginning, but its objective is to assist you at the very end of that particular process, whether it is an application, it's an appeal, it's a bail, it's a remand, it doesn't really matter what it is for, but that application is going to be with you till the end. And so let me give you an example. So this is a sort of a hastily constructed example. We're trying to show the difference between a good draft and a bad draft. So I'll read these 6 grounds that are being taken in a particular application. Let's say that this is a bail application, right? So the lawyer writes that the injury in the present case is not the cause of death. The appellant is innocent, has not committed any offense whatsoever. Allegations against the appellant are false and motivated. Alleged weapon used in the present case has not been recovered. Appellant had no intention to murder or otherwise harm the deceased. The appellant had no motive to harm the deceased. So from this you can surmise that the facts are that a particular person, the deceased, is no more. There's an allegation that your client has murdered him, and there's an allegation that a weapon of some sort has been used, right? If your client was in fact a doctor who was performing a surgery as a result of which despite which a person has lost their life, you could argue alternatively that the appellant is a surgeon, he's a registered medical practitioner, the injuries are the result of a surgical procedure conducted by the appellant to save the life, no material to suggest that the injuries caused the death of the deceased. So the tone and tenor of the 2 illustrations that are before you, one, which is this one, is something that all of us can draft in our sleep, because this is something that is generic. We know what is to be said. In any bail application, before listening to the facts, while your client is getting ready, they're getting the papers ready, etc., you can bang out about 15 grounds without even knowing what the case is about, right? Those 15 grounds will fit any bail case. But the fact remains that those 15 grounds, if they are so easy, if they are so common, the judge who is going to read them will discount those 15 grounds in every case. So those 15 grounds now form the baseline. So the fact that your client is innocent. So there are some matters I remember where we used to be told that you must state that your client is innocent. But the fact remains that anyone, almost all people who are going before a court seeking bail, that is going to be their baseline argument, that I am innocent. So going on and on about the fact that your client is innocent, has not committed the offense at the stage of bail, at the stage of remand, at those early stages, is not going to be helpful. So you can excise from your draft, or you can reduce the amount of space that you have dedicated to those grounds, and instead replace them with grounds that are functional, that require, that allow you to say what is it that you want to achieve by that one particular draft. There is nothing wrong with these 6 grounds if the fact situation remains the same. That is, this is a doctor, he is alleged to have committed an offense by opening up someone from stem to stern in order to try and save someone's life. Allegation, the family says that no, you killed him because he died, look at these injuries that he suffered. But the focus of your defense for him, again, depending on the stage, will not be those hackneyed old grounds that are there in every draft. And we all have them. I have drafts from 15 years ago which will probably say exactly the same thing. But these 3 grounds will be a result of you applying your mind to the facts, and anyone who reads these 3 grounds or grounds similar to this will immediately be able to understand what kind of situation your client was in and what is the fact situation that you're putting forward for your client, right? So, how do you achieve this? So, before I would attack a draft, proceed to actually start the draft, you must ask yourself, what is the purpose of the draft? And the reason this is important is, all of us in our computers and in our emails have drafts and drafts and drafts. Depending on which client has come, you are able to, like Hakeem's of old age, you are able to pick up portions and bottles that are relevant. So I may have a bail application, I have 15 bail applications, I have to choose a bail application where some client of mine was a husband, is being accused of cruelty, and therefore I will pick up draft A. If it is a case of a person who has been accused of driving negligently, I pick up draft B or draft C or draft D. But no two fact situations are the same, and are not the same, and while they may be similar, your object or your objective as a lawyer is to point out drafts that may be similar but not the same, and in that lies your skill set, that you are able to take two situations which may be similar but not the same, and you are able to identify before a court that, look here, I understand that you've seen 15 cases of negligence and you have been passing orders A, B or C. This is the 16th case that is similar but not the same, and it is not similar for these 4-5 reasons. The only way in which you are able to give or deliver an incisive argument is if at an early stage you have been able to identify that while this case may be the same, may be similar, it is not the same. So there has to be thought that goes into why is it that I am being asked to prepare a particular draft for a particular purpose. Because it is also your job, it is also part of your duty to advise against preparing certain drafts. So simply because someone comes to you and says, I want to file a bail application, or I want to file an appeal, or I want to file a revision, does not mean that it is advisable for such a person to file such a document. So you have to give yourself that space, the time to think about what is it that I am about to draft, and more importantly, why is it that I am drafting this particular document. Because the client may come to you saying that I want to file a revision, but it may not be in his or her interest to file that revision. It may be in their interest to file something entirely different. But unless you apply yourself to the purpose of the draft, what is it that that draft requires to achieve, what is the outcome that you want, you have to think about it. And the problem that I often have in my career is that without thinking, it's a bail application, no problem, I can do this in 15 minutes, I have the requisite draft, and you bang out a draft and it's ready. It will be ready in all respects, but if that thought hasn't gone into it, then you are now bordering on, just jumping in without actually knowing what is it that you want to achieve. There will be some drafts that when you're being asked to prepare, you have to be very clear on where is this draft going. In your careers, you are going to draft, as all of us have, you are going to draft legal documents that are meant to be mostly read by judges, by courts, different types of courts at different levels. Those same documents are also going to be read by the prosecution. So you have to be mindful that there may be two audiences for that particular document. It may be a document that is a representation, but also has to be drafted as forensically as any other document that you're preparing. So if, say for example, a person is arrested, you are requested to appear for that person in a trial court during a remand hearing, you appear at 2 o'clock and you are ready with remand objections because you know broadly what is it that the police are going to ask for. But you must also remember that a copy of those remand objections is also going to go to the prosecutor and to the investigating officer. So that is the time when your client's right to silence, right against self-incrimination, all that is kicking in at that stage. It's an early stage of the investigation. So conventional wisdom, orthodox wisdom in criminal law is that your remand objections should be as brief as possible, as bland as possible, you are at that point of time focusing on your client's constitutional rights more really than focusing on elements of the case itself, because the case is less than 24 hours, or around 24 hours old. So you have to be cognizant of who all may be reading your draft. And that is good, because a draft, so another example would be a bail application that you have in a particular case that is meant for the court of a magistrate. Those submissions may not be appropriate for a similar draft that you're preparing for the High Court. Those submissions may not be suitable for an SLP that you're drafting for the Supreme Court. So the nature of your audience, the amount of detail that that particular judge or court is willing to consider at that particular stage of the process, those are all inputs that you are going to be expected to provide in the draft that you're preparing. The criminal law process is interesting from 2 points of view when you're looking at it as a defense lawyer. From the point of view of the standard of proof and the burden of proof. These are two very interesting, sometimes competing, sometimes infernal concepts. It's difficult for us sometimes as defense lawyers. We want to introduce documents at an early stage. The burden of proof is on us in some of these special laws to show that I am in fact not guilty of an offense to try and get bail, yet I am stopped from placing material on record. So sometimes we feel that this is a square peg in a round hole. How do I do that? But if you are able to recognize at an early stage of your process of drafting that what is the stage of the matter that I am currently intervening in, and this seems very simple, but I began my career drafting in an office that was doing a lot of appellate work. So where we were filing quashing petitions or revision petitions before the High Court. And initially when the papers would come, you'd start drafting without losing sight of the fact that there's a trial ongoing. So this is an appellate proceeding that you're filing, you're approaching an appellate court, a supervisory court, you're in an extraordinary jurisdiction without knowing what is happening in the trial court. And what happens in the trial court has a bearing. The stage at which a matter is has an immense bearing on what is it that you're going to say, what can you say, what is appropriate to say, and as a result of which your expectations must be guided by what is the stage of the matter. So your applications, whether it's at all these are just illustrative, whether it's a remand charge, final argument, the burden of proof and the standard of proof continually change from each stage of the trial. So in the beginning, the burden of proof, while theoretically yes, is on the prosecution, but in order to arrest someone, they arrest on suspicion. They don't arrest on the basis of the same standards that are used to convict someone. Bail is denied if there's a prima facie case against your client in some cases. So again, the burden of proof is on them, but if they just say that, look, there are 161 statements against your client, so this may not be a good time for the person to be released on bail, the court may be persuaded there. But that burden of proof on in these matters keeps on increasing on the prosecution as the process goes forward. So at the stage of charge, again, the burden of proof is slightly larger. It's not just a prima facie case. It has to be that the charges are not groundless, right? So these are, and at the final stage, again, it is where they have to show beyond reasonable doubt. So you can almost imagine it as a steady increasing scale during the course of the trial. That is the standard of proof and as well as the burden of proof. So this will dictate what is it that you can say and to what extent do you have to back those arguments or back those submissions that you're making. So how could one prepare, right? There is a popular notion in several books that can guide you on how to prepare winning briefs or winning drafts. But there are various ways to begin, there are various ways to think about it. But the simplest way to think about it is that before you actually start putting pen to paper, after you've thought about your matter, you must have a case theory in mind. What is it that we are trying to say? Having a case theory in the context of a trial is slightly easier. Having a case theory with respect to, say, a bail application may be a little harder. Right? You may not have all the pieces for a small application. You may not require all the pieces for miscellaneous applications. But you should broadly be aware of the nature of case that is being presented against your client, what is your client's possible role, and what is your client's possible defense. It is in the backdrop of these pieces of data that you ought to have, that you will be in a position then to make an effective draft. You will know which arguments to impress upon or which arguments to let go of. If you are unable to identify a case theory, say I want to file an application for permanent exemption for a client, I don't need to know, say for example, in an application for permanent exemption, I don't really need to know what is my client's ultimate defense. Right? So that's fanciful because it's a smaller application. But it is not the same as filing an application for exemption for the day, where you can go in front of a court, you can sort of do your thing at 10 o'clock, say I'm sorry, he's late, he's doing this, he's doing that, and the court with a burden of whatever 70, 80 cases, they finally say all right, fine, this time and not again. But an application for permanent exemption is treated slightly differently. It's going, the notice will be issued, someone will file a reply to it, and then you will actually have to argue that. So whether or not your client has committed the offense is irrelevant to the decision on your permanent exemption case. But the requirement of that particular application will be to make out an objective, and make out in service of an objective being that your client should be permanently exempted. But those grounds are not going to be he is not committed the offense, or he is being falsely implicated. It will be that he cannot come to the court for A, B or C reasons. He doesn't live here, it's expensive, he has a medical issue, he has to go to school, he has to go to college, whatever are those reasons. So the nature of your draft will reflect, if you put thought into it, the objective of the draft, and that will shine through to whoever is reading it. It's easier for them to quickly go through it and then come to a decision. For larger drafts, such as appeals, revisions, replies to complex 482s, replications in matters where rejoinders have been permitted, in those it is always useful to map your draft, which is before you actually start hacking away at your keyboards, take a pen and paper and start structuring your draft, that these are the 3 or 4 things that I want to say. This is a recurring theme in, say, your finding a reply to a petition. This is a recurring theme that the petitioner on the other side has, or this is a recurring theme that I have, whether it is a theme of false implication, whether it's a theme where you actually have a defense, which is that this is a civil case, not a criminal case. So you have to bunch those grounds together. You have to map out, but this is how I'm going to structure my particular draft. And previous drafts, we are all, at least I'm definitely guilty of this, they are not templates, right? And that is if you remember this small thing, previous drafts are a guide, not a template, which means a previous draft should not come as a pre-packaged form where you just keep changing details, because that is where you're going to start making errors, and those errors are going to count as errors against you as a lawyer. So that's going to take professional points away from you before a court. Court is going to say, this is in 2024, you filed a draft that says 2021. So immediately, it's something that you can request, and if the court permits, you can correct that over the counter. But immediately the court knows now, because the court has seen in a day they see 70 cases. So you can take it that most courts have seen more matters than all of us. They know that this is a draft that is based on a template. Right? So it takes away from the urgency or the nature of or the urgency of your plea. It's not a good look for a lawyer, especially a young lawyer. Now, this is a section that I feel very strongly about as a lawyer, and I want more people to understand this and to recognize these as issues, which is identification of logical fallacies. So as criminal defense lawyers, we are often confronted by charge sheets or FIRs where our client comes back to us and says that, this is wrong. We also will believe what our clients are saying, and we also believe that what the FIR is saying is wrong, or what a statement is saying is wrong, or what a charge sheet is saying is wrong. It is our job to articulate what is wrong. And our articulation on behalf of our clients cannot be the words of our clients. Otherwise, we are not required really, right? If what our client is saying, if we are going to say exactly the same thing, then we are not needed. Luckily for us, all this work of classification of logical fallacies in normal thought, Western thought or Indian thought, has already been done about 2,500, 3,000, 5,000 years ago. Everybody has done this. This is not something brand new. There is a classification of logical fallacies that exists in Indian thought. There is a similar classification that exists in Greek thought. It is and has been refined thereafter. The advantage of going through these fallacies and understanding what they mean is that you are able to identify them in an argument. I'll give you a small example. These days the elections are on, and you are going to hear, we hear, these speeches, etc. on a daily basis. Sometimes a speech is made, and the response to that speech is, whatever he's saying is wrong because he's corrupt, right? Or she is corrupt, or he is nepotistic, or she is a dictator. So there are allegations, so there are two parts to that statement. One is an attack on the person who is making that statement, and the other is an attack to the contents of what that person is saying. Now this is largely understood, and many of us have come across the word. This is an ad hominem argument. That the argument that my opponent is making is wrong because my opponent is a bad person. The two may be entirely different and distinct. Simply because, to take an example, the prosecutor turns to your client and says that your client has a history of beating his wife, therefore he must have stolen this money. Now we must, in our capacity as lawyers, be able to identify these arguments and expose them for what they are. That's your skill. It's not enough to say that no, neither has my client beaten my wife, because we all remember complex sentences from legal methods 1, that if a question is asked, when did you stop beating your wife? That's a very difficult question to answer, right? You must be able to separate those two issues, that I never beat my wife, and therefore the question of me beating my wife or stop beating my wife doesn't arise. So, but that's not the extent of it. The extent of it is to identify this, that the fact that you are saying that my client, who may have a history sheet longer than my arm, but today when he appears before you, he is being falsely accused. The two are not related. That he has a propensity to commit crime may not be the reason why he has been brought before you today. The fact that he is known to the police, that may be the reason why he has been brought to you today, because it is easy to fall within this trap that he was arrested 15 times last year for chain snatching, therefore the 16th time also we are producing him before you. The arguments that are ad hominem, if they are picked up at an early stage, if you are able to identify them, you will be able to attack them appropriately, and you will answer them for what they are, which is a logical fallacy, right? And given the fact that ultimately before a court it is a battleground of ideas, right? It is the prosecution case theory versus my case theory, or our case theory. There are more than one accused, and the judge is invited to pick one which is most attractive for the day, and that really will be distillating into the order of the day. So whoever is quickest at being able to identify them and the ability to use them, I can't say that you should use logical fallacies, but at times you'll find that you are using logical fallacies, but we are using logical fallacies that have the support and the undergirding of the law. So say for example, I say that I am poor and therefore I should be granted bail. As opposed to for committing the same offense, a man comes and says that he is rich, and the court says, no, you are rich, you should not be granted. It's a bad example in what has happened in the last 2-3 days, but let's just take that as an example. The fact that a person is indigent and therefore ought to get bail over and above any other person who is not indigent, if that is an additional consideration. That is a consideration that is bestowed upon that process by law. Otherwise, We are all students of law, we are all students of positivist law at some point of time. There is no reason why, if you believe in true believers of equality, if two people have committed the offense, the same offense, they should be given the same punishment. It shouldn't matter whether a person is a man or a woman, whether a person is below 16, whether he's medically unfit today, or whether he's rich or whether he's poor. But the law says that no, we are going to treat all these people are not alike, we are going to treat them differently. And you as lawyers, all of us, we are expected to know what those categories are. And we are expected to use those categories. If clients fall within one of those categories, there are beneficial legislations available, you must be able to access them. So, but that does not mean that you should not, that you should be able to identify that this is not the norm. If you're looking at pure questions of logic, and our understanding of logic underpins our understanding of law. And exercise, we are reading any charge sheet today that is filed by any of the agencies, it is an exercise of unpicking their logic. And you will, if you go back and look at charge sheets that don't seem to make sense to you, you should be in a position to identify what is it that they have, where is it that they're making errors, right? So these are some common fallacies. There's an appeal to pity, which we've just dealt with, right? And these are all, I mean, you can see that there are Latin names for it. So this is not something that is brand new. This is very old, and there is immense amounts of literature on this. People take it as it used to be a sport earlier to identify these in newspaper articles and publish them. Together, famous journalists have fallen for these fallacies, right? So say, for example, the fallacy of false cause. So if someone says, where's your client today? Why isn't the accused present today? Well, he lost his job recently and therefore he can't appear before the court today. The two are not related, right? But you are now desperate to say something because the judge has put you on the spot. You know, you've handed the application to the reader. In a just world, no one will look at you again. But your now application has come up before the court, and the court says, well, mister, where's your client? So you have to, again, when you are drafting your exemption application, you have to be careful that the reason for the exemption is related to exemption. Why he can't be there today, not about his spotless moral character, right? So there are then examples of what is a straw man. This is another form of a logical fallacy, or an appeal to emotion. You'll find these in prosecution complaints, right? And a lot of you on the criminal side will be doing matters for persons who are not Indian citizens. So sometimes the allegations are, oh, you look at this person is from so-and-so country, right? Or this person is from a country who we don't like very much. That has nothing to do with the case, right? But that is an appeal to emotion. And an appeal to your patriotism, or the judge's patriotism, or the court's patriotism is as much an appeal to emotion as any other emotion. We may identify with it positively, but the curse of being a lawyer is that you have to be able to point that out, right? And therefore be unpopular on WhatsApp groups, right? So that's one of our difficulties. We just gave you an example of the ad hominem argument. Then there are begging the question, appeal to ignorance. There are at least 15 more like this, right? So the doctrine of slippery slope. There are deductive logical fallacies, inductive logical fallacies. So I would invite you to read these, to study these, with a view to ensure two things. One, that you don't do the same thing in your drafts, because there are arguments that you will make that you know are weak. Why are they weak? They will often be weak because they are relying on a logical fallacy. And at the same time, you will have the ability to identify these in your opposition. And if you are able to identify these in your opposition, it becomes much easier to answer it, because you are able to immediately identify why is it that this argument is valid. So, some of you may have noticed the chapters, barring the last one, are in the process of commission of a criminal act. So we've done the intention, what is it that you want the draft to achieve, the preparation, where you're getting all your facts, etc. together, and the next step is your attempt to actually make your draft. Again, often we prepare drafts a few hours before they have to be filed, the day before that. But even then, the first draft that you make should normally not be the draft that becomes the final draft. Because once you have prepared your draft, once you prepared the first draft of your application or your petition, you may have actually gained more knowledge about your particular case along the way, right? So the second half of your draft may actually make much more sense than the first half. Because the first half you're still thinking, what is it that I have to say? All right, I'll chuck in the facts here, chuck in some general grounds here. But by the time you reach you reach the meat of your application, when you're formulating your thoughts, and you finally found a good expression, or you found legal answers to what is it that you want to do, by that time the first half of your draft is usually stale. Right? So you must go back and read your draft in its entirety, and make sure that that revision that you're doing is not with respect to grammatical errors. Right? Most of us use computers that will pick up those grammatical errors. It is errors with respect to facts, errors with respect to the objective that you want to achieve, errors picking out remnants of earlier drafts that have gone in. So that process by which you are revising your draft is very important, again, to make sure that your draft is effective. While you are preparing your draft, you will also have, over a period of time, the ability to think of what is it that the court is going to say, or what is it that the prosecutor is going to say, the opposite side is going to say. If you come across that I'm preparing this revision petition, but perhaps there's going to be an issue on jurisdiction, or there's going to be an issue on whether or not this order is in fact revisable or not. Is it an interlocutory order? Is it an intermediary order? Is it a final order? If you come across that objection in your mind, please take the time to resolve it. Find that answer today, because whether you need it, you may not need it immediately today or at the time of filing it. It's going to come out in the future. So you might as well, in your files, make a note that this is a possible objection, keep that judgment, whatever is relevant for you, and pop that in. Right? So the process of your draft is really an internal dialogue that you are having, where you have to pretend to be the court, you have to pretend to be the prosecutor, you have inhabited the persona of your client for that particular draft. So it is an exercise that requires your concentration, right? It's not something that you can do, where you are not 100% concentrating on it, which is why the process of drafting itself is relevant to you, because if you are alive to yourself during that particular process, you will pick up cues, you will find that there are parts of your draft that are thin, you will find that there are parts of your draft that that require further consideration, and you must continue to have that dialogue with yourself. We often hear, as Sir pointed out before we started, that you should be brief. We keep hearing, and these are all lines that are there in our miscellaneous applications, that with the intention of being brief, we are not reproducing the facts in the petition, and the same may be read in. These are the same generic words that we use. But there are two errors that I have come across my drafting, which I try and weed out in the second round. One is that you tend to draft as you speak. The manner in which you would approach an argument, an oral argument, is very different from how you would treat it in writing. And initially, when you are drafting, you will tend to write, or you'll find some drafts where the grounds are as if someone was arguing before a court. An oral argument, or words that are used, or emphasis that is given in the course of an oral argument, looks very different when it is transcribed. Transcription often doesn't cause the same effect. So you cannot write as you speak, and that is a common error that is made, especially if you're dictating it to someone, or you're typing it while you are you're imagining the argument and you're typing it. You have to immediately go back to that ground, and you'll find that almost always there is a shorter way of stating that same ground, or that same particular sentence. There is great benefit in using shorter sentences, in using shorter paragraphs. These are all things that I'm sure all of us know. But there is a purpose for all of this. A shorter sentence is more accurate. It will deliver. You can use, instead of 2 large sentences that form a paragraph, you can make 5 sentences. And each sentence, it may not sound great as prose, but we're not writing to impress. It's not literature. The purpose of this is transference of information. You're transferring information to a court, say in a bail application. But those facts, the usage of words like and, but, where you're trying to connect 2 sentences together, sometimes may alter the meaning of what is either before or after. It may dilute a particular fact. So, as far as possible, use short sentences. Make sure that your sentence is being used to deliver one fact or one aspect of an argument, and don't hesitate in stopping a sentence short. We, especially all of us who've studied in public schools in India, some of us will remember N. Martin, etc., from when we were going to school, where there were these long sections on the difference between passive and active speech, and we were often told that as far as possible, please use direct speech. But there is a reason why in some situations passive speech is actually may actually be tactically useful, right? So if I were to be describing an incident where someone has had an accident, instead of saying I was driving a car that ran over the victim, the car that was driven by me may have, in some sense of the term, driven over the victim. Passive speech emphasizes the deed as opposed to the person who has committed the deed. You have to be truthful in your draft, but you also have to be skillful in your draft. The object of the draft is not to present a mea culpa to the court, right? That's not the purpose. The purpose is to be able to defend your client. But in doing so, you want to emphasize certain facts and you want to play down certain facts. The facts that you're playing down is the job of the other side to bring out. But whether you do it deliberately or you do it unintentionally, passive speech has the unique ability to lessen the role of a doer, of a person who is actually an active participant in a particular sentence. And so you can either make use of it, but almost in 60 or 70% of the cases, as Indians writing in our public school system, we always tend to speak in passive voice, especially when we are writing. When we are formally writing English, we are almost always doing it in passive. When you switch it to direct, the immediate benefit is that your sentence becomes shorter, it becomes crisper, and it is something that is far more pleasing to read than when you're talking about what is happening to a particular thing. I think Sir also pointed out the lack of benefit sometimes of using legalese or very thick legal prose. In almost all applications that we file on a daily basis, legal language is a hindrance rather than benefiting your client. Because just as I pointed out earlier, just as you are tired of saying the same thing again and again, courts are tired of reading the same thing again and again. So the moment a ground comes that looks like it is copied out of one of our sterling judgments, the court is also going to almost certainly skip over that part, saying I know what this is, I know where this is headed. And if within that block of text you actually have an original thought to say, that original thought of yours is going to be lost. So that is one end of the spectrum, which is excessive use of legalese or Latin phraseology. At the same time, the other end is that I must use normal English, but I must send my draft through a thesaurus first, So to find the most obtuse possible words that I can use so that the court feels that this is definitely something that they want to pay attention to. And there are, I mean, we don't need to go into our draft. There are judgments that many of us, no matter how many times we read, we can't understand because of the same difficulty. The objective of our writing, all our writing, whether it is us as lawyers, as prosecutors, as judges, is to convey a legal thought or to convey a thought in a manner that is understandable to everybody. Nobody is getting points for complicated legal language or complicated English language. We have nobody, no, not one person you've never seen on bar and bench or on live law that look at this great draft that has been said, right? It is all about oral arguments that are excellent and judgments that are interesting. Nobody cares about what is written in the drafts, right? But at the end of the day, your draft is what is going to remain on the file. Your draft is going to be what remains on the record. And in our system, where sometimes appeals are delayed, you are going to be faced, as I'm faced with several times, appeals that I have drafted 10 years ago. I'm reading them and I'm praying that this doesn't come in my lifetime. I'm going to have to defend this horrible appeal that I had drafted, without keeping in mind at least some of these things 10 years ago. So the language that you're using will reflect upon you. And there are cases where the judge asks, look, you've written this word, what does this mean? And if you then are floundering at that moment, then really, you have to find a way to get the matter adjourned and, pray for change in roster. The fact that your draft needs to be concise, accurate, and effective means that you have to put thought in it, and thought before you actually start drafting it. All of us, if let loose with a laptop and a printer, will be able to churn out 15 pages on topics that are given to us off the top of our head. But it is only if you are able to apply thought, you have you spend time on your draft. It doesn't really matter whether a draft is small or large, that only if it is a constitutional matter, only then will I hit the books. It doesn't matter one bit how minor that draft is. Each draft is a reflection on you as a professional, and it has a requirement. If it is not required, you will not be asked to draft that. Nobody files applications for the fun of it. So and especially not in criminal matters. So all these drafts that you're preparing or that you're thinking about, if one of these three elements is missing, if it is not concise, it is not going to serve much purpose. If it is not accurate, you're going to put your client in greater trouble, than your client is before the draft. And if it is not effective, then that's the end of that, insofar as your involvement is concerned. Now that, unfortunately, is not the end. So when you finish your draft, while we all want to stand out in those 60 matters that our fictional court is considering, that does not mean that you can add borders or that you can change the color of your font, you can add pictures. You have to format it in a manner that is reflective of your standing as counsels in our bar, and our bar is a well-respected bar. So these are things that you must spend time on. The draft must be properly formatted. You must keep yourself abreast of practice directions, because even in matters that you have done very well in, you've got a POXO matter, you've drafted an excellent matter, if you have not followed the practice directions with respect to how to deal with cases of sexual assault, there are some things that need to be removed, some things that cannot be highlighted. You will again, for no real reason, find yourself afoul of a court. So please, and there aren't that many practice directions, they're all available on the website, so please take the time to once in a while just leaf through them. You should be, you should have access to them just to make sure that these basic principles are met. Rules on filing and e-filing, they sometimes change. Please make sure that, and the reason all these are important is that if you have been given a file on a Monday saying that look, this matter has to come up on a Friday, when you are budgeting for your time, how much time do I actually have to think about the draft? You must also budget for things like this. That has to be settled by someone. It has to be filed. It will take time in filing. So you have to keep subtracting that from the time that you have on the draft. So though you're getting a matter on Monday, it has to come up on Friday. So it has to be filed latest by, in the High Court at least by noon on the Thursday. So the amount of time that you actually have for your draft is almost always much shorter than you think that you have. And on e-filing, I think in particular, there is a new terror that we all have, which is what version of the draft has finally gone to the court. And I have a habit of giving similar names to the file, bail application, appeal, revision. So you don't really want a situation where revision for client A is going for client B simply because it's lying in the whichever folder you're using to upload. So whether you're doing it yourself or you're requesting a colleague to do it or you're requesting a member of your staff to do it, these are things that you must be careful of. And the not so much because these cannot be rectified. These often can be. These are errors that can be rectified. But these are errors that reflect on us as lawyers when we do it. It means that we are not applying our mind at the relevant point of time. And the last thing you want to do as a lawyer to project to the court is that you are not taking care of the fine print. And any reference to fine print, in popular media, etc., is a reference to lawyers, right? So if we don't take care of the fine print, then who will? During the course of the preparation of your draft, whether it is in the beginning or at the end or in the middle, as much as possible, I understand many of you will be dealing with clients who are incarcerated, who are not available to you, but as far as possible, you must continually correspond with your client, and your client must be aware of what is going to be filed in his or her name, and whether that means that you have to take a time out to explain the contents of the draft in a language that they understand. And merely because someone speaks English does not mean that they'll understand the draft. You have to take the time out to explain the contents of the draft, what it means, what are the possible consequences, and what is it that should be expected, what kind of timeline should be expected. If you are in a position to do that regularly with your clients, you will find that that if we have a very coarse word for it, which is expectation management, right? It's a way of explaining to someone what the road ahead lies, and that's really our value as lawyers, that we are able to tell someone what is likely to happen to them, what is going to unfold for them, with their interaction with the criminal process. So what are finally the consequences? Your ability to deliver a good argument, on your application will begin from the preparation of your draft. You can't first file a draft and then think of the argument that you are going to make on the final day. While the draft application or petition serves a valid purpose for your client, and that's really what it's there for. But as lawyers, we must be careful of our own reputation. It is a reflection of whoever has drafted that petition. And the fact that it is a reflection means it can be a good reflection or a bad reflection. Every draft you might not be able to knock it out of the park by saying, by creating some new argument in each case. But you can almost certainly make sure that each draft that you file, no draft that you file, reflects poorly on you as a counsel. Right? And over a period of time, you should be able to say that the quality of your drafts has improved. Because if in 24 you are using the same drafts that you were using in 21 or 20, or they seem similar, that should raise some alarm bells for you as a lawyer, that I've grown. My arguments may have improved, but if my drafts remain the same, that means somewhere there is a disconnect. Your drafts, I'm sure they do, but they should also improve over time. And I think with that, I will conclude. Thank you for your time.
Thank you, sir, for such an informative session. We would now invite questions from the audience related to today's topic. You may kindly raise your hand and the mic shall follow you. I think we have no questions because sir has...
Thank you for the session, sir. The question is mostly regarding, we have a lot of criminal revisions, I'm on the matrimonial panel, and there are some times when it's very difficult to find a good case theory, or the objective is obviously to set aside the maintenance that's been fixed or get stay. But it's very difficult to find a good ground. And I completely agree with you that the simpler the draft, the simpler the language, the clearer the draft, the easier it is for the audience. But in these cases, is it at all advisable that your draft is more confusing than enlightening? Because if it's very clear, then you also know that maybe you don't have a very strong case. Does it make sense to try and beat around the bush, make it a little here and there to just at least get notice issued on the matter? Because there are a lot of times when it's a very straight case of being married, have to give maintenance, that sort of a thing.
Fair.
So sometimes you know that your case is not good enough on merits.
Correct.
In that case, this is a good idea because everything is there.
So I think that's a great question. Your draft should be simple, not simplistic, right? So there's a difference. I appreciate what you're saying. There's that common saying that if you're good on your facts, you go on your bang the facts. Bang on the facts. If you're good on the law, bang on the law. If you're good at nothing, then you bang on the desk. So we've all done that, right? You've just gone there with a mood to pick a fight with the other side so that the matter gets adjourned. So all right. So that's all part of, that's part of your courtroom strategy. So there will be given cases where I'm sure it makes tactical sense to infuse in your draft language or facts that are designed to, I won't say be economical with the truth, but to bury the other side in paperwork. Well, that's fine. That's a strategy that may well be your strategy for that particular matter. But you're doing that with the understanding of what you're doing, right? As opposed to every draft, even if it is for permanent exemption, is 14 pages long, right? Then there is a problem. So if you have identified for yourself that this is a problem, and I'm going to need to introduce 3,500 pages of my last income tax returns just with a view to bury the other side in paper, fine. I mean, if that works, great. Every draft is not going to be simple. There are complex, as we all grow older or as we get our different matters, you are going to find matters where you have to file very complex pleadings in whether it is in criminal law, you're all doing different fields in arbitration, in civil law. But the objective of attacking your draft with a view of understanding what is going into that draft remains the same. You may end up with a very complex draft, but then you're doing it knowing that that's what you're doing. And having told your client that, look, this is what we're doing because there's 90% chance this is going to die on notice.
So, sir, while filing bail applications, at initial stage when the charge sheet had not been filed, so should we disclose and write a proper defense which we intend to put through the trial, or should we put up a simplistic kind of a bail application? Because sometimes the court says you have not disclosed this and this was never your defense. And if we disclose the defense, that lacuna can be fulfilled by the prosecution.
Yeah.
So,
you're right. So again, on bail we have the happy situation where, quite apart from the special laws, our general law on bail is a 3-part test, is a tripod test with 4 parts, right? So somehow we manage that. That we have the 3 general, that you will not abscond, you will not influence witnesses, so on and so forth. And the 4th part of the tripod is that you must have a prima facie case. That's part of our law now. So you have to answer a prima facie case to get bail in many kinds of matters. There are matters where you will be able to get bail on a 2-page application. But there are matters where you will find that there is a need for you to give some sort of an explanation. depending on what your defense is, you may want to disclose it in some cases, we may not want to disclose. I would tend not to want to disclose my defense, even at the cost of, so the way I would rationalize it with my client is that, look, you're going to be released on bail eventually, no one's going to keep you inside forever. But you're going to be stuck with your trial for a lot longer. So it's not going to be much fun if I get you out on bail. And then, you're sent in the blue bus 3 years from now because of submissions that you made during your bail. So we'll have to wait for the charge sheet to be filed, let the case of the prosecution be crystallized, and then you take your defense. But I take your point that there are some courts that will say that, look, you've not said anything about your prima facie case. So you do have to say something about it. And that's really your skill set. How can you take 3 facts and go on and on about it for 1.5 hours that the judge also feels that yes, he has said something about the prosecution case. But that's where normally I would find great support from prosecution status reports. That's always a great place to start, right? Because in saying nothing, they will give you enough material for you to at least try and make out an arguable case for bail. So that's the balance that you have to meet, the imperative of the right to silence. I've never seen a case till now where someone has been silent throughout the trial and has succeeded. Right? So this right to silence it exists, but it doesn't mean that you can be silent during the extent of a trial. You have to speak at some point of time. So your skill set is on identifying areas or times when your client can speak.
Thank you, sir.
No, there's a same question as to what about at the stage of charge? I've had a situation where charge sheet is filed and I'm aware about everything. But I tell a prima facie case that if you read the charge sheet and what they say, so the prosecutor says, oh, we'll file a supplementary charge sheet and we'll say that what I was arguing, that you're saying that 304 is made out, there is no injury.
Right.
My client who suffered injury and you forged 304 on us. He says, no, we take a subsequent medical opinion saying that these injuries can be possible by the instrument which is foul, or there is no blood or anything. So drafting for discharge also is a tricky situation.
There's no doubt about it. And in fact, in some of the recent matters, I won't take the name of the matters, but there was a profusion of bail applications in one set of matters, and this was despite advice from some of us that, look, just file basic bail applications, even if it means losing in the first 2 rounds, go to the High Court and by that time you'll get your bails. But there was contrary advice received, and before magistrates and before sessions court, these 50-60 page bail applications, and that's not with the annexures, just the application were being filed. The prosecution were using it as a manual, that is, where all is it that we've gone wrong. And the effect of that was that there were tighter prosecutions that were being filed in newer cases, and previous cases where we had rock solid defenses for different people, that they were not there at the spot, their phone numbers have not been seized, the wrong identification. Suddenly there were new statements, and in every case it's not a case where the prosecution is fabricating material. There may be genuine cases where they've not done a good investigation. Some senior officer said, look here, this is a travesty, please do a better investigation, and they may actually find material. But at the stage of charge, say for example, there are arguments that are available to us in many matters where I have actively advised my client, please don't take that ground. At the cost of getting a charge framed against you, don't take this ground, because as you're pointing out, the prosecution will try and cure this defect. And it is not our job to perfect the case of the prosecution. So there are grounds that can be taken at the stage of discharge which fall short of that, which is a mixture of legal factual grounds where with your experience you'll be able to tell that this is not perhaps a ground that I want to expose before the court today, not for any other reason, but it's their job to on the prosecution to put together a case that stands on all fours, or on that. So if a leg is missing and there is a possibility that that leg can be found somewhere, then I would prefer to take the hit on charge for that particular argument. there will, in any case, there will be more than one set of grounds available for you to take that forward. The difficulty is that if my background is in trials, so I'll be quite happy to go to trial on those facts. But if an appellate court lawyer, someone who's steeped in appellate court practice, looks at it and says that this is rubbish, right? You have to take all available grounds right now. Well, maybe that's the ground that will appeal to a superior court. So you can have, a divergence of views on this, but orthodox, conservative criminal law will say, be silent, take the hit, move on. You'll be better served later on. But it's a tricky area.
Hi, so I'm fairly new to criminal law and IPC in general. So I just wanted to ask, you mentioned about remand where we mainly focus on the constitutional rights of the accused, that such and such are the rights of the accused, so these are the submissions. So similarly, how does the essence of the document and the objective of the document changes with other documents like bail applications and petitions or charge and other applications of under the criminal law?
Right.
Can you just briefly?
The reference to constitutional rights is that at that point of time, presumably you don't know enough about your client's facts, but what you do know is that, and there are now enough and more judgments from the Supreme Court where, on the basis of violation of constitutional rights, people have been getting, their remand orders have been cancelled, arrests have been found to be illegal, bail is being granted on grounds that are effectively your failure to provide grounds of arrest, failure to produce someone within 24 hours. So those are grounds that will find some relevance at a remand court 24 hours after the investigation, where the courts are not really looking at your defense at that particular stage. So the objective of remand objections are relatively rare. Most people don't file them anymore. But the objective of a document at that point of stage, at that point of the proceeding, would be to place on record certain facts, which is that they are saying that I was arrested at 7 p.m. Actually, I was arrested at 2 p.m. Right? They are saying that, my medical has been done, no medical has been done, or coercive processes have been used against me, I've been beaten, whatever are your facts. So you're also using it, you're leaving a marker for yourself later on at a later point of time. If you want to refer back to that document, you have that, look, this is what I said one day after my arrest with respect to the process. The objective of a bail application is entirely different. Now, it's not as if that where you're looking at an objective, you're not looking at constitutional protections. Those are there. That thread will continue. But the objective, by the time you reached your first bail, you have at least one remand application. You'll have a remand order. You'll have the remand application for judicial custody. So you have a collection of material. You would have spoken to your client. You've spoken to your client's family. You now have a much more rounded understanding of what has gone wrong in this particular case, or what are the allegations against you, as you did on day 1 or day 0 when you were sitting and preparing a remand application. So the objective then is slightly different. The objective is that you want to get your client out on bail. Your objective may well be not to get your client out on bail, but to extract a status report from the other side. Right? Which is, I know this is too early to file a bail application, but I need to know what's happening to the other accused persons. So I move a bail application, get a status report from the prosecution, and then take a call on that.
So what do you think about the future of legal drafting in emerging AI technologies and technology?
No AI is going to be able to draft, for us at least. Because AI is grammatically correct, there will be no spelling errors, it will be properly formatted, no one will believe that that lawyers have done it. I think its impact is going to be felt on slightly more mechanical aspects of legal drafting, which is document handling. So you can see its impact in arbitrations. So when you're talking about diligence of 200,000 documents, which used to take 15 lawyers 2 months, that can now be done by a team of 3 lawyers in a week 10 days. So first, and AI functions where there are easily digestible formats. There has to be some basic set of rules that you're able to give to the AI engine before which it is able to churn out material or drafts, etc. The system that we are currently following
I don't think it is currently designed in such a way that an AI engine is going to be able to churn out these documents or churn out these drafts immediately. I think it's still some distance away. That's my opinion.
And as a youngster, since you're just starting out, I would strongly recommend don't walk that path. Apply your mind, because otherwise the machine will start thinking for you.
Correct.
Don't use chat, GPT, etc. Use your own brain. Take time, think it through, and then draft.
Yeah. Yeah.
I've taken some key that I've not done this thing. But tomorrow in 313 statement I was saying, okay, I've done this thing but with consent. So there are contradictions in draft of my 313. Does it have any impact, sir?
Of course it does.
So of course, to be careful in the beginning.
That's whether it has, you're able to explain it away, you're going to have to explain that difference at the final stage. Now, you may have a good explanation for it. I was incarcerated, I couldn't communicate with my client, my lawyer made an error. So a judge may overlook it. You may go the other side by saying that, look, I can take contrary defenses which are equally untrue, but unless the prosecution proves their case, that does not mean I can be convicted on my falsehoods. I can take false defenses. I can say I was not there, I can be proved that I was there. The fact that I said I was not there doesn't mean that I did it. Alright, so you can take both sets of defenses to that, but you added work for yourself.
Right. So even while making the first draft,
yes, which is why it is so important. Which is why, although people on the civil side make fun of us that you guys don't actually have to draft anything. One date page पे तो draft होते हैं, क्या ही काम करते हो तुम लोग. But there is, your skill set is in what you are not saying, more or less. Right? That's where your skill is being put, your experience is being put to use. That I can say so many things about my client, but I am deliberately not saying it.
Because when I joined profession, these bail drafts were not on affidavits, but right now they're on affidavits. So it should have a consequence.
Yeah, it will 100% have consequences.
Thank you, sir.
So my question is related to bail applications, and specifically in the cases of 306 IPC or 304B IPC. Sometimes even the clients are not able to explain that why she committed this suicide. So sometimes we don't have any explanation to this why.
Correct.
And even in the cross-examination, we are able to show the falsity of the case. We are able to show that this story is cooked up story. They are not right, and they are cooking up this story, and they are just making up this theory that I was harassing her, or I was demanding a dowry, and that is why she has committed suicide. Still, we are not able to explain why. Sometimes this why is, the courts are not inclined to grant bail because of this inability of explaining why. So, in this situation, how should we tackle this situation?
See, you are referring to cases where there is a burden on you to prove, or on you to make that. There is a reversal of burden.
Right. We are explaining to the court that we had a very good relationship. I was taking care of all the needs of her, but still she committed suicide.
Right. But what is the standard of proof that is required of you? Right. I would explore that question. That do I, at depending on the stage of the matter, I may have an obligation or an onus to actually give some kind of explanation as to why the deceased committed suicide, or what has happened to the deceased, at least insofar as what is known to me. But I am not required to express that in a form that reflects a standard of proof being beyond all reasonable doubt. Right? So you have that ability. So again, you have some facts, you have a lot of law on this. Right? So there is an immense amount of law on that burden when it is reversed onto the accused. The standard of proof is preponderance of probabilities. So at least you are in a position to give your explanation. You serve your explanation on a bed of that on a bed of that law, right? Which is that, look, this is the law. This is what I'm expected to do. So my inability to provide you today with a better explanation is a reflection of the law. It's not a reflection of me. I only have to do it to a preponderance, and this is a preponderance. So if you're bad on facts, then you have to look to the law to help you.
Due to paucity of time, we won't be able to take any further question. And thank you, sir, for so patiently answering all the questions. And thank you for your presence here today. With this, we have come to the end of today's session, and I thank all the empaneled advocates for their participation today. I would now request everyone to kindly proceed to the lounge area for the high tea. Thank you so much.
Thank you.